Well, this morning, instead of the hot tub curmudgeon, I am the lakeside raconteur. So, here is something I do not understand about the interrogation of nominees to the Supreme Court. You can't ask, like, how would you rule on an abortion case? You can't ask that. But what you can ask is, uh, number one, what were the issues in Roe versus Wade? Now, if a nominee does not know what the issues were, he shouldn't be a nominee. Then you want to ask, what were the possible legal theories of the majority that voted for it? What were the possible legal theories they could have used to get to the result that they got, and what were the legal theories of the dissent? If a guy doesn't know that, he shouldn't be a nominee. Okay, so in the case of Roe versus Wade, the majority came up with something called the penumbra, and as I understand it, if you have a total eclipse of the sun, then the image of the sun around the moon is the penumbra. Okay, so that part is not blocked out. Well, so the Fourth Amendment provides privacy in certain areas. You can't have an unlawful search or seizure. Just to give you a little background, I was in law school and we were looking at the constitutionality of police searches of a defendant. Now, you can scrape under the fingernails to see if maybe some of the victim's skin is under their fingernails. You can make them do a voice recording to compare to a telephone message. You can clip their hair. But you can't pump their stomach, and you can't shove things up their bunghole to search for stuff there without a court order. You can go get a court order, and if a judge thinks that you have reasonable cause to stick something up their bunghole, well, then you can do it. Okay, so I raise my hand. I say to the professor. Now, the professor was this very, very, very good Mormon. They had adopted something like 8 children, and he just was a super Mormon and one hell of a cool guy, but he was also just this scary character in our law school. So I says, now, Mr. Dean, I was reading that women are creating a lot more crimes these days, and so there was this case where 3 women held up a bank, and so when the FBI showed up to talk to the tellers, they asked this male teller, so what did the lady look like? I couldn't tell you. What, were they wearing masks? No, they weren't wearing masks. Well, then why can't you tell me what she looked like? Well, because they were wearing see-through blouses. I don't know what their faces look like. So, of course, now this Mormon law school criminal law class is erupting into laughter at this point. Mr. Deem is looking a little bit flustered, and I said, so here, Mr. Deem, could you require the suspect to stand in a lineup with a bag over her head in a see-through blouse with other suspects, in see-through blouses, to give the teller an opportunity to see if maybe he could identify her and pick her out of a lineup? And the class is uproarious. And Mr. Deems gets all flustered. Funny, he says, Mr. Kirk, if I have to explain to you why that wouldn't work, you're too young. So anyway, the Constitution provides a right of privacy in certain areas. And so, the Constitution does not specifically provide that you can't pump a suspect's stomach. But we've decided that yes, it does. That you do have that much privacy. The protection against search and seizure protects you from getting your stomach pumped unless a judge signs an order. Okay, so a lady wants to abort a fetus, and the state says no, you can't do that. So is the state saying no, she can't, an infringement of privacy similar to the state saying, hey, we're going to pump your stomach without a court order? Is there a similarity there? And what I guess the William O. Douglas court decided was that there is a penumbra of the right of privacy that, although the Fourth Amendment, it wouldn't specifically or even very compellingly address state prohibitions against abortions, there's this penumbra of rights. Okay, so you got a nominee in front of you and you say, so what was the logic that the court came to in Roe versus Wade? If the guy can't tell you, he shouldn't be a nominee. All right, so let's say that he does tell you. And then, to me, it's a very appropriate question. Well, do you believe there is any such penumbra? So like, what is the scope of the right of privacy? The Constitution could not have contemplated the ability to pump your stomach or search your bunghole for balloons full of heroin. That could not have been contemplated by the Founding Fathers, and yet it has been decided, yeah, you got that. You have a right to the privacy of not having your stomach pumped without a court order. So Mr. Nominee, explain to us, where's the edge of this penumbra of how much privacy do you have a right to? So Connecticut, for a long time, I guess, was predominantly Catholic, outlawed birth control. Well, so if a man wants a vasectomy, does his right of privacy override the state's interest in prohibiting birth control? And you can ask the nominee those kinds of questions. Where's the edge of this penumbra of the right of privacy? And I just don't understand why people opposed to a particular nominee fumble around with these questions that they're not going to get an answer to. Why don't they ask for what was the legal reasoning? What is your legal reasoning? How would you extend or how would you contract the penumbra or whatever the thing was? Good morning.